important, in the context of an acquisition. When I start working with my clients, especially US-based, as I was saying, mid-sized company looking to acquire primarily a technology business in India, the first thing sort of I start counseling them with is, think about an acquisition generally, right? I mean, if you're acquiring a business, put yourself in the shoes of anyone, or think about yourself as acquiring any other business. Then we talk about India, right? So in any acquisition, doing diligence is, I would say, equally important as structuring the transaction itself, especially if you're on the buy side, right? You're stuck with the liabilities if you're acquiring the business itself. So nothing changes from that perspective, right? Your perspective coming in should be, if I acquire this business, what am I stuck with? What are the things that can go wrong? And who should take basically the risk of those things going wrong? And then how do you sort of factor those into the valuation, the pricing as well? If you apply that concept to India, then sort of you have to have your concern level or your red flag sort of higher, or your radar should be even higher, because now you're looking at, in many times, a foreign jurisdiction where you're not familiar with the process. If something goes wrong, many times, your CEO or your senior executives have to fly down. As Nishit had said earlier, in India, if there are liabilities or unpaid account, financial, taxes, the directors of the company could be personally liable. So again, what you don't want is, if you're the in-house lawyer at a company that's acquiring a business in India, you don't want your CEO to be suddenly getting subpoenas from Indian courts for liabilities, unpaid liabilities. So you want to make sure that's done and taken care of properly. And generally speaking, understanding that if things go wrong, how do you exit out of it? If the business itself doesn't work out, or what you had contemplated in the original business plan doesn't play out the way you had contemplated, and if you had to exit, because in the US it's very, very, very easy, right? You shut down a business and you move on, but it's not the same in the Indian context. So understanding that, and then using your diligence to apply to that instance as well is very important.
Thank you. And Josefa, what have been the most common issues that you find in due diligence when you have conducted all these due diligences? Can you just throw a light?
Sure, of course. Sure. In fact, we've got such a good audience out here. Would anybody want to, just voice out what do they think, what issues they found in diligences, and I could add on. Just, I'm sure you guys have companies, or you've done diligences on companies. You just wake up from the coffee break as well. Any thoughts?
Corruption.
And
true, very true.
Very true.
Mm-hmm. Corruption, taxes, and
unpaid taxes, right? So there are the tax litigations. Yeah, so we've at least nailed 3 right here. Anything more?
IP rights.
I think we've got very good.
Then we have also the labor laws.
Exactly, labor laws, IP, corruption, corporate. Yes, please.
I haven't done much in India, but have done big time in USA.
Sure.
Infrastructure is a very important thing. When GT and Bell Atlantic merged and became Verizon, I was leading the M&A.
Sure.
Then you have to look at all kinds of assets.
Yeah.
Roaming assets and, technology licensing, infrastructure, cell towers, even leases have become very important. It all depends on the size of the company.
Yeah.
And in India, I know what it may be, but I have not physically done any of that.
Yeah. Fair. Very, 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 very valid and good points made by the audience. So I'll just sum it up, quickly for the benefit of all. The typical takeaways which we find when we are undertaking diligences, especially in technology companies in India, the first which usually comes out in all Indian companies are corporate compliances. Now, most of you may know, or if you don't know, Indian companies at times, if I may use the word, get careless, from at doing corporate compliances. So they're not the best. So, there are always some loopholes which are there. I'll give you a classic example. At times, the board of directors is not constituted validly, which means that, yes, there is a board of directors which is functioning, but the appointment of one of the directors or the approval of the appointment of one of the directors may not be correct. So what does that mean? If the board is invalid, the actions undertaken by the company are not valid or are invalid. And that also exposes the company to certain violations of certain applicable laws. So the basic thing, right, you need to have a good board. So that's again corporate hygiene. Your corporate compliances need to be in order. In India, you need to make certain statutory filings on a periodic.
Can I just interrupt for a moment?
Yes.
Let me give you one interesting example that we had some years ago. You know, in India, you need 2 shareholders and 2 board members, okay? And at one time, the board member resigned. There was only 1 board member. The shares were issued by 1 board member, okay? Now company is doing good. Now this is sought to be acquired by another company from the US, which was to go public in the US, okay? Indian company is doing well, okay? Later on they appointed 2nd director and all that. Now they would acquire these shares, and this US company was to go public. What we found, that the shares were invalidly issued. Now you go public with this kind of situation, it's a huge issue. So the small non-compliance had a big issue because invalid issue. The first thing you write, some of you are very experienced, you know, entrepreneurs, and first thing you say, shares were validly issued. Most of the people routinely read that. But really speaking, these are the kind of issues sometimes you feel when you have not really taken care of small compliances, and that's very important. Sorry for my interruption.
Yeah. No, actually, that was the next point which I was going to get into.
Oh, I'm sorry.
That is, but it's partly covered. It's in relation to shares, right? Ownership of shares. Today, one of the most important things when somebody is buying your stock is they will ask you, have your shares been validly issued? As Mr. just mentioned, you know, that the smallest of minutiae of non-compliances at times may become a big issue. So in India, one is your title, that is whether you own the shares. For that, you need to always ensure that while you're doing a diligence, that you know, the shares have been validly transferred if they've been transferred from point A to point B or person 1 to 2. And second, the share transfer forms have been endorsed. So that would, of course, and it has been approved by the board. Moving on, if there is a cross-border element involved in which there is a non-resident Indian to whom shares have been issued or to whom shares have been transferred, there are certain statutory filings which need to be made. One is with the Ministry of Companies and also with the Reserve Bank of India. They're called exchange control filings. So one is, of course, you need to ensure that the title to the shares is okay, but what is extremely critical is also the exchange control filings are done validly well. Because tomorrow if you want to exit that company or you want to buy a company, all these questions are always going to come up. Moving forward, a lot of technology companies in India are set up in special economic zones or special incentive zones. A lot of people may have heard of these things, but what does that entail when you're doing a diligence on them? The basic benefit of setting up a unit in a special economic zone and an incentive zone are there are certain tax subsidies. So when an Indian company is being acquired which has a unit in a special economic zone or a special incentive zone and a lot of values derived from that unit, you need to ensure that that particular entity or that unit has fulfilled its compliances and obligations of its special economic zone or incentive. If they don't, the pitfall is that once the company is taken over, when you buy that company, the tax subsidies may not be availed or may not continue if those obligations or compliance have not been met.
No. I said we have slightly short time, so
I'll wrap up. I'll not get into too many things, but the last concluding point on this, which I want to make, is on litigation. Right, the biggest fear which people have is that, oh, if I buy that company or I touch that company, what is the litigation exposure? What am I getting into? So unfortunately in India, there is no central repository system where you just key in the name, or a government system where you key in the name of the company and you get to know that this company has XYZ litigation going on, or 1, 2, 3, 4. The only way you can get to know probably is you keep probing and you keep asking the company, or look at the balance sheets of the company and see if there's any contingent liabilities there and dig further. But always be mindful. And one basic exposure on technology companies with a company in the US with a company in India is the transfer pricing litigations which are usually on. the related party transactions. So that's one thing which you need to ensure that that's okay. So I think I'll sum up that, from a larger level on diligence issues, and I take it forward.
Yeah, and I think what was pointed out by the members of the audience on the FCPA, often there is not enough recognition, including in technology companies that are selling technology to infrastructure companies, because all government contracts, government is the biggest consumer of all these technologies as well today. So we shouldn't underestimate that harassment issues and many other ones that we take a look at it. But let's go to Simon, maybe, if I may have attention. How are diligence risks mitigated? Is there any heavy reliance on representations and warranties? What do you do?
So, Nishit, I would just want to add one more thing that, in terms of diligences, and we can go ahead and discuss how they're sort of mitigated. One thing very key to note about Indian companies is it's very relationship driven. So contracts and the way a business functions, it's very relationship driven. It's not always very corporate. So what you see may not always be what you buy. So it's very important from a diligence perspective as well, not to just do a documentary diligence, but to really understand how business is actually conducted and how will business be conducted post the acquisition. Very often we have great presentations made, documents reviewed and things like that, but every contract can be terminated. And not every contract is actually in writing. So it's very important to understand source of revenues, how is business being conducted, and how will it be conducted post once the original acquirers or original shareholders actually leave. Second, what is very important, and we've all heard about the Satyam scam, and Josefa sort of talked about related party transactions, is that the way Indian corporations are structured, you have the promoter that owns a large part of the stake of the main company, but that promoter also has incidental or ancillary companies, within his fold. What exactly is the relationship between his, other companies as well as the main company is extremely important to understand, so that you have a fair understanding of what the revenues are going to be post the transaction. Is it circuitous? Is it real revenue? Are they, really third-party contracts? So a lot of time, a lot of energy is sort of spent in understanding the business and understanding what is actually third-party, what will actually remain, and what is within the fold of the promoter. How are these risks actually managed? Now, one is of course understanding and having discussions with your contract, with your customers. That's one way to sort of manage business risks, at least to understand continuity post the transaction. In terms of diligence, findings and risks, very often you will see that the seller really wants to consummate transactions within a day, or wants to sign the agreement and consummate the transaction the very next day. But in India deals, we see a bit of a gestation period between the time that you actually strike the deal and you complete the deal. The reason that is that because you have a host of conditions precedent which you would like to sort of get completed before you actually get into the company. That could include cleanup acts, could include certain filings to be made with regulators. It could include, ensuring that contracts are well documented. In India, you have a lot of stamp duty laws. You need to ensure that certain contracts are actually stamped for them to be enforceable, or for them to be admitted into evidence in a court of law. So these are the kinds of conditions precedent that you would see typically in deals, especially tech deals. So one special emphasis on diligence findings and how you will sort of wrap that up as conditions precedent. Sometimes what happens is that, especially when time is of the essence of the deal, you would move certain non-critical conditions precedent into a condition subsequent, formula where you have a limited time to complete this. Now, if you're doing 100% acquisition of the company, a condition subsequent makes no sense, because in essence what you're doing is that you're telling the buyer, I will take on this liability going forward and I will complete it myself. If you're doing a part acquisition, a condition subsequent could make sense because at least some onus lies on the existing shareholder as well. So that's when conditions precedent play a very important role. We also have, of course, the concept of representations and warranties, which are backed by indemnities. Now, representations and warranties, are they heavily relied on, one might ask? To that, the answer is yes. For instance, we talked about the diligence process, that it is, in essence, what is the diligence process? It's what the seller really wants you to see, because you rely on the seller for information for you to do the diligence. In India, you don't really have electronic records or sufficient electronic records to run a diligence process by yourself. The minute you require the aid of the promoter, of the seller, then it's a question of how much he wants to reveal to you at the time of diligence, because there's always a fear that if he's disclosing too much, you may not want to do the deal. When you have a vast number of representations and warranties, and we will talk about the disclosure letter, an onus is there on the promoter to actually disclose against those representations and warranties. And there you would have a plethora of things which you might not have seen in the diligence, and we'll probably deal with that later. But representations and warranties are heavily relied on from an India deal. Enforcing them is different, but at least it puts the acquirer on notice, or saying that you are representing to me that this is the status of the business. You also have indemnification. So every rep and warranty is backed by an indemnity claim. And we will deal with what the terms of an indemnity could be in terms of specifics. What are the minimum thresholds? Maybe in session 4, where we talk about key deal terms. But indemnity is extremely important. Now, to mitigate risks of a disclosure letter vis-a-vis an indemnity, you also have specific indemnities, notwithstanding any disclosure letter that is actually being made. So specifically, if there are certain liabilities that are looked at, which are extremely key, or which the acquirer finds extremely key, you can specifically ask for an indemnity for that matter. And of course, you have price protection. So if you have a liability which which are not very key, it's very important to ensure that any term sheet you sign has a specific provision in that term sheet that the purchase price may be adjusted depending on what the diligence findings really are. So that's a very important aspect, and you can then discuss price protection and price adjustments at the documentation stage. So this is what you would do to sort of mitigate or to take care of diligence risks.
And anything about escrows or stuff like that, or insurance, or how do you?
So Nishit, in India, escrow agreements, it depends on how you actually structure the deal. If you're doing an India to India deal, that means if you're doing a purely domestic deal, an India deal, meaning a foreign acquirer is acquiring an Indian company and Indian shares, and you're dealing with an Indian seller, exchange control regulations sort of protect the Indian seller and require for the consideration to be paid upfront. You're not really entitled by way of right to have deferred consideration. You are not entitled by way of right to take out from the purchase price, keep it in escrow, and then pay later. You require a specific approval from the Reserve Bank of India to actually do that. These approvals are forthcoming, but they do take time. So if time is essence of the deal, this is something that you can't really do. If you're doing a completely offshore transaction, a non-resident to a non-resident selling shares of an Indian asset, of an Indian company, or you could look at escrow mechanisms where a part of the consideration is put in an escrow and then paid later as an indemnity escrow. However, again, if time is of the essence there as well, not too sure how that will actually work. So typically what you have as well is what is growing in popularity in India is the indemnity, is the rep and warranty insurance that is being looked at. It comes at a cost. but more and more we see acquirers and we see sellers actually taking these policies. At least there is some sort of certainty that there's somebody else that's going to back the indemnities that are given by the seller.
Who typically pays for that in the transaction?
Well, we've seen them to be both sell side as well as buy side. Indemnities, insurance covers, and it's a bargaining power that you have. So you have both sets of both sets. They are expensive, so they could be they could go up to 8% of the total deal price. But again, it depends on it depends on the company. It depends on what the limits really are. What is the indemnity for? For tech companies, the limits are probably less because of the perceived risks here. So it depends from company to company, but it could range it could range anywhere between 3 to 8% of the deal size.
Maybe at this point in time, because we are running slightly short of time, it would be useful to get the questions if there are any, and is there any particular question or anything that would be helpful?
So Nishit, just one comment before we move on to the questions. I think two big ticket issues which we haven't addressed in this panel are the issues in relation to employees and IP issues in a company when you're acquiring. Since it's a very focused discussion, we'll be taking that topic in the next panel, which focuses on employee and IP issues in M&A. So I just wanted to make that point.
Oh, thank you. Yeah.
Yeah. In India, especially, I'm looking at a lot of solar farms and similar energy farms and require the access to the land, ownership or lease or whatever. And the history for the land, I understand is, look, I've been here for 35 years, so I'm just saying, I understand that it's going to be very, very difficult, and based on what we know and what I hear. So what are the things that we can do to circumvent it? Not that it's a problem.
So yeah, this is a very valid question, and which actually gets raised in a lot of multinationals who are actually setting shop from an industrial perspective, where the land is vast and it's a heavy asset, right? One of the things which we've seen our clients do is have a lawyer or a law firm who's extremely good at doing title diligences to property. And you get records, like if in India, even now, if you go to the registrar which maintains the land records, you can pull out historic records probably dating 50 years back, and they actually pull that out for you, and they'll give you a title diligence report which will confirm whether the title to the property is valid or not. So I think that's a must which you need to do.
So again, acquiring land, as you rightly said, is difficult in India. We're trying, the government is trying to corporatize these records. So maybe in 10 or 15 years, we won't have this problem, hopefully. But it is a problem in India. The best way to do, to acquire land is to mitigate the risk to the extent that you can. And to a large extent, it could be also a leap of faith. What we've seen people do is give a public notice in a newspaper saying that you are going to be acquiring this. You give a public notice. At least you put it on record, or you give notice to the public at REM that this is going to be an acquisition that you're doing, so that tomorrow, if at all title is ever challenged, you can have at least some sort of prudent norm that you can show to a court of law, saying that this is what was done. There was a public notice granted. This is, of course, backed by a title diligence report, a title certificate granted by a lawyer, and you would have these two things to at least go to a court of law to suggest that you have some stake in this battle, as opposed to none at all.
Yeah, I think very quickly.
Yeah, quick follow-up, please. For the land, I understand there's what's called Benami word that I come across quite often. Second thing is, if a scheduled caste or someone owns it, you can't even do anything. And that diligence is one thing I'm always afraid of for large farms that I'm dealing with now.
So it's not really scheduled castes. It's more, in India, land is slotted into various areas. There are tribal lands. There is agricultural land. So agricultural land and tribal land is something that is very protected. you can't just buy agricultural land. You have to convert agricultural land into non-agricultural land to actually buy it and construct commercial property on it. So there are various nuances to land that have to be looked at carefully.
Yeah.
It's not the person owning it, but it is the nature of the land that depends on, and that drives circumstance.
And there are
I would
few.
add, actually, we had an experience about the restricted use, converting restricted use land to a commercial land, and if the seller is telling you that they'll get it converted, don't believe that, right? Either it will not happen, or they'll end up paying somebody to get that happen. So you're still, if you're a US company, you're also subject to all of those FCPA or the corrupt-related laws. So be extra careful when the seller is promising that, don't worry about it, we'll get it converted, and certainly don't make it a post-closing covenant. You want to have that done up front.
And I think.
Thank you, yeah.
I'm Linda Brownstein from Footprint Ventures in Bangalore. I have a question about the filings. And we had one company where we had a direct investor, one of our limited partners came directly in, a non-Indian limited partner came into one of our companies and then was able to sell shares in a subsequent round. The company had made all of its filings, but the law had changed, and it was a smallish company. They were unaware that the law had changed, and they didn't refile under the new law. And it took a very long time. We had one of the Connie Chung-like war stories that was related earlier, what happened to this investor, because it was so complicated to get RBI approval for this, investor to get their money outside of India. So my question is, in situations like that, and we've talked about the fact that the law keeps changing over and over again, when it is a legal matter of filings, and even if the company has done its proper filings, how do the companies know and who is responsible for making sure that the companies are aware that a new filing needs to happen in a particular area?
Anyway, India follows one principle, that ignorance of law is no excuse. So you need to be on the top of it, and often, rules change. And only one thing that if it's good faith kind of infraction at times, usually penalties are waived and interest are leviable at times. So and prosecution is waived because it's not intentional. At least to some extent, we have a kind of a criminal or quasi-criminal jurisprudence incorporated in most of our laws. So
It wasn't that kind of a thing. It was no penalties or prosecution. It was just they couldn't get their money out.
So typically, especially for exchange control filings, it's the company as well as the authorized dealer that is, those are the key elements of any exchange control filings. The authorized dealer is nothing but the bank through which you actually remit the money outside India. Therefore, that relationship has to be extremely strong. Typically in India, and yes, it is a developing nation, and we are going to be having, multiple law changes. But typically, what happens is that there is always a moratorium period of about 6 months granted for any, if there is a new filing to be made, the government typically grants 6 months for companies to actually make that filing. So yes, it's extremely important to sort of stay connected and sort of be vigilant on these things. And, we will sort of add you on our database so that you can have some sort of, recurring reminders and new filings that need to be made. But typically this is what happens. 6 months is the grace period granted for recurring filings to be made. Like I said, the relationship between the company and the authorized dealer is extremely important. So when trying to develop a banking relationship...
Authorized dealer is a bank, by the way.
No, I'm aware of that. We have all of that. That wasn't the issue. But anyway, thank you very much.
Yeah.
Yeah, let me add one point. This is a very important point which I should have also raised in the first session. When an investor is making any investment in India, and you have to ensure that company does the filing, what you call FCGPR filing or FCTRS filing, depending on it's a primary investment or a secondary investment. And once you did that filing, you have to ensure that Reserve Bank of India has accepted or acknowledged that filing and have given you a UIN number
which is the unique identification number, which acknowledges that they have accepted on the record the investment which has come in. Because when you exit, and when you have to remit money from India to outside India, which was in your case, Linda, the bank will require the original UIN number, before which they will not allow that money to be remitted. And so the question which you asked, how do we ensure that we have done the filing right? The way you will ensure is that you get the UIN number which Reserve Bank of India gives. If you have a UIN number, which means your filing has completed its logical conclusion, mere filing a form with the authorized dealer of the bank, you may feel that you have done your job, but if bank does not then take it over and send it to Reserve Bank of India, and Reserve Bank of India does not take it on the record and send back you the UIN number, then that's not completed filing, and often delays will happen. Now, responsibilities of the company, but the person who suffers is the investor, since his money gets stuck. So the penalty, if at all, on non-compliance will be done by the company, but the deal or the money which will get stuck will be of the investor. So I would recommend, and that's what we recommend normally, is any investor who is putting in money has to ensure that their corporate records have been accepted by Reserve Bank of India and has got UIN numbers. So that will take care of all your issues.
Sure, Anil.
I'll just share a very quick, interesting story. At least in 10 years later, it seems interesting. We had represented eBay in its acquisition of Bazi, a business, one of the first acquisition technology, cross-border acquisitions. Right after that, the law had changed around some, so I'm glad at least you're aware that laws can change in India, so you're vigilant about it. But right after the acquisition, the law changed and they put the CEO of Bajaj in jail because he had, or the company had apparently violated the new IT Act. And nobody really knew what the IT Act was, but the short of it is, if there was any pornographic materials on a website, then you as a website owner could be liable for that. And that also led to bailable warrants against the CEO of eBay. And as you can imagine, one of the partners at my firm got a call saying, what do we do? And our response was, send a warm blanket, and that's really all you can do. It's literally had to work on the local ground at the police station level. There was nothing you could do other than work on the local level to get that guy out. And again, just be aware that laws can change, and it's trust the seller, but verify. Have Nishit in India do the diligence, make sure that while you trust the reputations, everything else the seller's counsel is telling you, your lawyer should be looking at making sure everything's sort of cleanly done as well.
Hello, okay. So I was advising eBay when they acquired Bazi, and we had actually told this to Avnish of all the laws which existed. And the problem often is how you interpret law keeps on changing. So law may not change, but the interpretation of law may change. So often, when we advise, it was taken saying that no, the risk is very low, but then suddenly he had to go in jail for 48 hours and risk became very high. So what you need to keep in mind is that not only law will change, but sometimes the way government looks at the law may change, the interpretation may change. So I think that was the point I was trying to make.
Good. Any other question for the time being?
Yeah, I want to add one more point over UIN number. One of my client who has not UIN number then cannot raise more funding by ECB, because for ECB you need all UIN number, otherwise you cannot raise foreign loan also. So UIN number is very important.
These are small things that sometimes matters and create a big problem. I know, absolutely. So I think these are some of the things. Slightly out of time, of course, almost by 15 minutes we have exceeded, and I would like to move on to the next session quickly. But we really thank you, Anil, thank you, Simon, thank you, Josefa.